Good morning, class. I'd like to welcome you to today's class.
Good morning, sir.
Good morning.
Good morning,
Nice.
sir.
Sometimes.
Good morning, sir.
Thank you.
Good morning, sir.
Yeah, good morning. All right, so we welcome you to this morning's class, and we are going to continue from where we stopped in our last class. For those of us that were with us on that day, we began by looking at statutory interpretation, which can also be referred to as canons of interpretation, or attempt to examine the various tools used in interpreting the law. And in the last course of that class, we gave reasons for statutory interpretation. And of course, we all agree that it is important, based on the reasons provided, for there to be a thorough look at this topic, more so that no matter how careful the legislators may be, because they are human, there is a possibility that some error or ambiguity may be created. And aside that, we also pointed out, by reason of that class, that there are quite some reasons, important anyway, reasons for statutory interpretation. And of course, we focus on the fact that there is need to ensure that there is clarity and consistency in the legal application of the law. So that makes it very important for us to look at this subject. And also another reason is to prevent misapplication of law, or to prevent a situation where the law is abused due to improper interpretation or failure to embrace the intent of the lawmaker in interpreting law. So, to prevent the misuse of law is one of the major reasons for statutory interpretation. And also, the purpose of interpreting statutes is also to prevent conflicts within available laws and to resolve ambiguities. Yes, it may appear that the word may appear simple enough to understand, precise, and without any form of ambiguity. But in the course of application, there may be need to actually take a thorough look and to arrive at a definition that is suitable to the present situation, and at the same time to meet the end of justice. And also, another point we can raise from our discussion earlier on is that one of the major reasons for statutory interpretation is to adapt laws to changing circumstances in our society. As we, as human beings, are growing, the society is growing, and then the law also needs to grow. And when that happens, it's only necessary for the law to be applied properly, and apart from properly, to ensure that justice is done in either way. So, with that foundation that we have laid, we are going to proceed to looking at the various canons or rules of interpretation. And the first one we are going to look at this morning is the literal rule of interpretation. The literal rule of interpretation. And then we ask ourselves, simply put, what does this rule of interpretation connote? Now, this rule of interpretation is also known as the ordinary and natural meaning rule. Ordinary and natural meaning rule. It can also mean the plain word rule. The plain word rule. It can also mean the grammatical approach. Okay? So I've said that the literal rule of interpretation can mean ordinary or natural meaning rule. It can also mean the plain word rule or the grammatical approach. So basically, from the what I've said so far, I'm sure everyone whose mind is in this class can have an idea of what this particular rule of interpretation is all about. So the literal rule of interpretation is based on the premise that the office of a judge is not what we call jus dicer or jus dicer, as some of us will pronounce it. That is, that the office of the law of the court is not to state the law. It is not to give the law. Okay? The law has already been given by the arm of government saddled with the responsibility to give the law, that is, to make the law or to present the law to the society. So, the office of the judge is not what we call jus or jus dicer, as in JUSDICERE. That is to state the law. They are not to give the law. So, the legislature already has that duty to give law. And that's why we're saying that making of law, amending the law, is one of the primary functions or powers of the legislature, which, of course, is the arm of government that possesses the power to make law. So a court cannot take upon itself the duty of uttering words or of inserting word in or into an enactment. So what therefore is required is that the law has to be seen as the legislature have made the law. So simply put, when we're talking about the literal rule of interpretation, we are simply saying that the court ought to give the law, give the word that appears in the law their plain ordinary or grammatical meanings. Okay? The court is expected under this rule to give the word that appears in every legislation their plain, ordinary, or grammatical meaning, even if it will lead to an undesirable outcome. That is where, or the position that the literal rule of interpretation puts forward. Now, I will refer you to the case of honor. Honor is spelled O-N-A-H versus attender, A-T-E-N-D-A. In this case, the Court of Appeal held that if the words of a statute are themselves precise and unambiguous, then no more can be necessary than to expand those words in their natural and ordinary sense or ordinary meaning, which is that state the law as it is, as it has been presented by the legislature. So when the words contained in a statute are clear, it is unnecessary to travel beyond the statute for the purposes of construing them or for the purposes of interpreting them. So the word is to be appraised based as it appears. This is the position that the literal rule of interpretation holds. Yes, as legal minds, we may have cause to query that what if a judge, misapply the provision or the words as contained in this law? That is it that the law does not seek after justice? The law seeks after justice. That is not in contention. But this rule of interpretation is of the view that the words as contained should be applied based on their ordinary meaning. So I'll take you further as we look at the case of Idehe versus Idehe, where the Supreme Court held that the first and most elementary rule of construction is the literal rule. So one way or the other from this submission, it is obvious that the Supreme Court believes in the literal rule of interpretation. So, but of course, the advocate of the literal rule of interpretation believes that the legislature has said what it means and what it has presented is what the law is. That is the position that the advocate of the literal rule of interpretation holds. And then the Supreme Court, in the case of Idehe and Idehe, maintain that same position, that when the words are clear, precise, without any form of ambiguity, it is expected that the court should go ahead and present it the way it is, because it simply represents the mind and the intention and the purpose for which the legislature seeks to achieve. So what it means further is that the intention of the legislature must be ascertained through the medium of the word used. For example, again, in the case of R and Bangaza, case of R versus Bangaza, Section 319, sub 2 of the Criminal Code came before the court for interpretation. And what does this section 319, sub 2 says? The law says, where an offender who is the opinion of the court has not attained the age of 17 years have been found guilty of murder, such offender shall not be sentenced to death, but shall be ordered to be detained. That is the provision of section 319 sub 2 of the Criminal Code. And that was what was before the court. And the law simply says that where an offender who is in the opinion of the court has not attained the age of 17 have been found guilty of murder, such offender shall not be sentenced to death, but shall be ordered to be detained. Now, applying the literal rule of interpretation, the court held that the relevant age was the age at the time of conviction and not the time of commission of the offense. Now, if you followed me in the course of reading that provision of the law made it clear that if the court finds out that at the point of sentencing an offender, that this individual is only 17 years old, that the court will not sentence him to death, but rather will detain him. There must have been argument to the fact that the law says, oh, that the focus of the law was that when somebody commits an offense at age of 17, that is not the intent of the law. The intent of the law is that at the point of conviction, if the individual is found to be 17, then he shall not be sentenced to death. So there was argument as to what is the relevant year or age. Was it at the point when the judge or the court is to pass judgment, or at the point the individual committed the offense? So the focus of that law, when you look at the literal rule or canon of interpretation, is that the words are clear enough to suggest that the intention of the legislature is that if at the point of sentencing, that means that an individual can commit an offense at the age of 16, and the time within which the case went for trial and when judgment is to be delivered, the person is now 27 years old. The court applying that rule, that law, literally will find the individual guilty, because at the point of conviction, which is the focus of the court, the year in focus was now 27, not 16 years. 16 years was when the individual committed the crime. But the purpose of that law has to do with the time of conviction. So that is the position of court in that, based on that law. Now, let's look at the case of UBN versus Ozigi. UBN versus Ozigi. Ozigi is spelled O-Z-I-J-I. In this particular case, there was a mortgage deed with a provision that empower the bank to stipulate the interest rate from time to time. The Supreme Court held that since there was a clause to the effect that the bank could stipulate the interest from time to time, the clause has to be given its natural meaning, and therefore interest has to be paid at the rate stipulated by the bank from time to time, and nothing more. That there will be no need to read other meaning into it. Let me digress a little to say that we have, as a matter of fact, the Yoruba proverbs do not, the meanings are not derived from what are the actual sayings. For example, the Yoruba adage says, or let's just even the English idiom or whatever, that says, a word is enough for the wise. A word is enough for the wise. The Yoruba adage says, abọ̀rọ̀ là ń sọ fún ọmọlúàbí tó bá dénú ẹ̀ ó máa di odindi, meaning that you only say half a word to an individual, and when the individual receives the word, it becomes full or a whole word. Now, from the English word or a phrase or whatever of a word is enough for the wise, meaning that literal meaning is that give one word to a wise man, or a word is enough for the wise or whatever. Give one word to the wise, then it's okay. Whatever is going to use the word for does not matter here, applying the literal rule. But when you look at the word itself is loaded. Oh, one word, a word is enough for the wise. The actual meaning that is interpreted into it is that you don't need to say much. You can make sense out of what you have been told. But literally speaking, you can just interpret it on the face of it. So I believe with that kind of explanation, we already have an understanding of what we're talking about, just to simplify. So in that case of UBN versus Sozigi, the clause there provided that the bank will be at liberty to stipulate interest. Of course, had to do with the presidential election. Of course, had to do with the presidential election of 1979, and the Supreme Court was dealing with the meaning of the provision of Section 34A, sub 1C and 2 of the Electoral Act of 1977 as amended, which had provided that to be elected, a candidate must obtain the highest number of votes cast at the election, and not less than 1/4 of votes cast at the election in each of at least 2/3 of all the states in the federation. The law provided, and I repeat, that to be elected as president, any candidate who obtained the highest number of votes cast at the election, and not less than 1/4 of votes cast at the election in each of at least 2/3 of all the states in the federation. And in that case, the case of the petitioner was that the declaration of the respondents by the returning officer as the winning of the presidential election was a nullity, since the respondent had not complied with the requirement of that section 34A. In that, instead of scoring over 25% of the vote cast in 13 states, he scored that percentage only in 12 and 2/3 states in the then 19 states of the Federation of Nigeria. As at that time, 19 was the total state. Then how do you determine the 2/3 of 19 states? But what the court did, applying the literal rule of interpretation, is that the court held that 2/3 of 19 states is 12. Is 12 2/3 states, if there's anything like that. 12 2/3. But what happened was that the petitioner was not satisfied with that interpretation, and he then applied to the Supreme Court. Of course, the appeal was dismissed. When the court was to dismiss the appeal, His Lordship Fatai William CJN, speaking for the majority of the Supreme Court justices, held that the words being construed were plain enough and that there was no reason for doubting the intention of the legislature. The majority rejected the other canons of interpretation urged on the courts, that is the other one that we have not discussed, and approved the literal rule of interpretation of the word of the subsection, which they consider to be very plain, unambiguous, plain enough that it should be understood from the face of the law that what the law contemplates is that the individual must win the highest number of votes cast and not less than 1/4 of vote cast at the election in each of at least 2/3. That the issue of 2/3, the word 2/3 does not carry any form of ambiguity. It's clear enough. That was the position of the court. But of course, it's difficult for you now to query the decision of the Supreme Court when the Supreme Court has given its judgment as it lies in its wisdom. So therefore, the literal rule of interpretation was given the approval in that case. Now, the literal rule of interpretation was also applied by the Supreme Court in another case of Nwocha versus Governor of Anambra State. Nwocha versus Governor of Anambra State. The issue was whether the Governor of Anambra State was the proper authority to exercise the powers or functions vested in or exercisable by the military governor under the provision of the Land Use Act of 1978. I repeat that again. The case of Nwocha versus Governor of Anambra State. I said the fact in issue was whether the governor of Anambra was the proper authority to exercise the powers or functions vested in or exercisable by the military governor under the provision of the Land Use Act of 1978. What the court said, as spoken by His Lordship Kayode Esho GSC, he held that the ordinary meaning of the word vested in will clearly suggest that the land which was vested by Section 1 of the Land Use Act of 1978 on the military governor of a state has now become vested on the civilian governor of the state. Because the law used the word vested in. So the Supreme Court just went ahead to look at it that vested in the governor can now either mean whether a military governor or a civilian governor. And that was the position of the court in that case. even despite the various blessings that the Supreme Court has given to the literal rule of interpretation, the rule has been criticized on several grounds, which we as individuals should also look at. Maybe I should allow us to point out areas you think that this rule of interpretation lacks perfection. Class, anyone? Anyone? Yes. Ogabo.
Good afternoon, sir.
Yeah, good morning.
Good morning, sir. Okay. So I'd say in the fact that applying this rule, there is the problem of the laws being applied to a case. It might not actually lead to justice in that case, because just applying it as what has been written might not actually turn out in justice. And also, there are cases where the court might not really understand the meaning of what was intended by the legislature. So if they just apply it as it is, maybe in the dictionary or what each word stands for, there's the case, there'll be so many cases of injustice.
I quite agree with you, Favor. Thank you very much. Let's listen to others. That's a beautiful one. Yes. Yes. Nkwocha, you want to speak because you had a case against Governor of Anambra State. Let's hear you.
Okay, that was a coincidence. So I
Really?
just want to
Are you sure
to
the man is not one of your forefathers or your uncle?
probably, I don't know.
All right, let's go.
So for this canon of interpretation, which is a literal rule, just like my colleague said, if some cases are used, or if this interpretation is used in many cases, it could really wrought injustice. I'm trying to get to refer to the recent case of AG Federation versus AG Abia State and 35 others. I think the ruling just came out as regards the autonomy given to the local government, especially as regards their funding. We went through that case in our group, and then we realized that one of the judges made mention of the fact that the rule or the canon or the rule that was, or the rule of interpretation used, was the purposeful rule instead of the literal rule. Because if the literal rule was used to decide that case, it would really wrought a lot of injustice. Because obviously the issue of there were many issues raised, but one of the prominent issue was the issue of whether or not funds should be sent to the local government via the state government, maybe like via the state. There was a trust account, I've forgotten the name, there's an account which local government funds have to be sent through, and the state government would disburse to the local government. This is what has been going on since, and obviously it has wrought a lot of injustice and all. But after this case came up, they said if they use the literal rule, which is what is clearly stated there actually in the constitution or in the statutes, if they use that literal rule explicitly, it would wrought a lot of injustice, as we can see. So the purposeful use was used in that case to make the local government autonomous so as to aid development. And I still remember reading the fact of the case where one of the judges, I think Judge Tukru, one of the judges of the Supreme Court, held that if that why he had a dissenting view, stating that the literal rule should be used in this case because what was stated in the act as regards sending funds into the specific account and then it to be disbursed to the local government was clear enough. That why are the judges using another canon of interpretation? But of course, he was the only one who had that dissenting view. Hence, the ruling of autonomy of the Lagos State still stood. But I'm just pointing out the fact that one of the judges pointed out the canon of interpretation used in that case, stating that the rules or the act was clear enough, stating that money should be disbursed into such funds and then disbursed to the local government. But this proposed rule used is making it different. But he was just the only one who went through that part, hence the ruling. That's what I want to mention. Thank you.
All right. Thank you very much for that beautiful contribution. Yes, Collins.
Oh, sir.
Good morning.
Yeah, one of the problem with this literal rule of interpretation is that there is little room for liberal interpretation. Like there isn't judicial activism. It doesn't give room for judicial activism. So that's one of my contribution.
All right. Thank you very much. Theodora. Yes.
So I wanted to say that it's like diminishes the roles of the creative role of judges in interpreting statutes. Like they'll just be mechanical, just interpreting it as it is. It's not really giving effect to the words of the statute, like the reasoning, and it can end up. And it's just like assuming that all lawmakers are active, they're all wise and all of that. But in reality, judges and lawmakers, they concern themselves more with like contemporary issues, things that are going on currently, and they can't keep like revisiting all the existing law and all of that. So it can be like suffocating. I don't know what word to
All
use
right.
there, but
Thank you very much. You got a note from your seniors, I guess.
notes.
Is that what? Hello? All
Sir?
right. That's fine. Thank you for... Yeah, no, that's okay. Thank you for that contribution. As a matter of fact, the various contributions that we have gotten have, to some extent, put more light to, what we have to say about the criticism for that canon of interpretation. Now, like Theodora rightly said, one of the major criticism of the literal rule of interpretation is that it seeks to diminish or extinguish the creative role of judges in the interpretation of statutes. And of course, thereby just make the judges to be, there's anything like the announcer of the law, just on the face of it, without creating the room to look inward on the construction and even the intent of the lawmaker. Another area is that it makes the lawmaker to be all-knowing, meaning that they could even foresee the future, and then they have made law to cover everything that you can think of. Of course, situations change or changes as society continues to change. So that cannot make the legislature to be all wise already. And the truth about the matter is that most legislative houses concern themselves with contemporary issues rather than going or revising existing law for the purpose of removing defect. So sometimes it is the present that the law, focuses on. And then the literal rule of interpretation also reduces the statute to just an arbitrary rule that sometimes you don't put reason to. Because if it is just to carry it and read it, then it has provided a rule where reasons are no longer necessary than to just go ahead to pronounce it. Okay? So it's these are the the critical points, criticism of this canon of interpretation. Now, it can also bring about unjust result. Let me refer you to the case of R versus Harris. R versus Harris. Report says is a 1836 case. And what does it mean? What are we bringing out of there? Now, is that a law made it an offense to stab, cut, or wound? Okay? That if you stab, you cut, or wound someone, that is an offense. The court also ruled that biting off a person's nose was not covered by the law because it did not involve a weapon. What the court did, what in applying that literal rule, is that when you want to stab, you definitely use something. When you want to cut, you use something. Or when you want to wound, you also use more like a tool. The court, the rule, going by the literal rule, did not envisage the possibility that somebody could bite. I think recently one of you guys, beat a lecturer. I think that was part of the thing I read. It was not just about insulting the lecturer. The student wanted to bite the lecturer or something like that. In that case, it was the court rule that biting the nose was not covered by that provision. Okay? So that is one of the position here, that applying the literal rule can bring about injustice. Okay? And like I said, applying the literal rule does not allow the court to read contemporary happenings or situation into available laws. But the unfortunate thing is that it is difficult for the legislature to even to make law for the future, because what was obtainable in terms of tenancy law as at 2 years ago in Lagos is not what is obtainable now. So things continue to change. Another issue with this class of canon of interpretation, it brings about over-reliance on drafting precisions. Over-reliance on draft, that is, the legislature have already drafted a perfect law, and that is not possible, because if the draftings were not properly done, to the literal rule of interpretation, it's not important. What is important is that the legislature is the Alpha and the Omega in respect of this matter. And since it has given its word by writing the law, so be it. Okay? So basically, the literal rule of interpretation provides some certain it provides, why we think that the literal rule of interpretation provides some level of certainty and consistency, its rigidity often leads to unjust situations, and other canons of interpretation with the purpose of attaining justice. But in spite of all these criticisms, it's still important to note that you can see some of you are supposed to be in this class in the market, and when they fail now, they will be saying that I attended all lectures. Well, thank God, the records will always show. They keep deceiving themselves. All right, so that's okay. But it doesn't take away the fact that, all these criticisms does not take away the fact that when the wordings of a particular law are precise, unambiguous, they should be used. Okay? And that's like a summary of what we're going to take under the literal rule of interpretation. Now, let's look at the second rule, second canon of interpretation, which is the golden rule of interpretation. The golden rule of interpretation. This canon of interpretation modifies the literal rule of interpretation to avoid ambiguity or injustice or absurdity. That is what the golden rule does. And what is the origin of this golden rule of interpretation? The golden rule of interpretation is attributed to the celebrated case of Park B in the case of Beck versus Smith. And the provision of the law what the court came up with is that the golden rule of interpretation is a very useful rule in the construction of a statute. And that justice is the focus. So if it is used in interpreting the provision of the law, the end point is justice. So the golden rule of interpretation allows for a departure from the literal rule. That's why I said briefly when we started on this that it modified the literal rule to avoid absurdity. So it allows for a departure from the literal rule when the application of the statutory words in the ordinary sense would be repugnant to or will be inconsistent with some other provision in the statute, or even when it will lead to what the court consider to be an absurdity. So clearly, the reason for the introduction or embracing the golden rule of interpretation is to see that justice is achieved at the end of the day. So the golden rule can also be referred to or can also be called the purposive rule or the purposive canon of interpretation. And what stands at the foundation for the rule is that is on the assumption that every legislation has some underlying purpose, and that in construing the words of the legislation, the court must give effect to the purpose of the legislation, not just the word as appears on the surface. Therefore, where to apply the word literally is to defeat the obvious intention of the legislation and produce a wholly unreasonable result, the court, in order to produce a reasonable result, must do some violent or must do some departure or some justice to the words that have been used. So, where the ordinary meaning of the word, as proposed by the literal rule of interpretation will lead to manifest absurdity or will manifest repugnancy, the language may be varied or modified so as to avoid such situation. In all of these, Lord Denny gave a position on the golden rule of interpretation. And to tell you, Lord Denny is outstandingly the most forceful exponent of the golden rule of statutory construction, meaning that Lord Denny is one of the most popular of those behind this canon of interpretation. Look at what he said in the case of Seaford Port Estate Limited versus Asher. I repeat that case again. The case of Seaford Port Estate Limited versus Asher. Lord Denny said, and I quote, "It will certainly save judges trouble if acts of parliament were drafted with divine prescience and perfect clarity. In the absence of it, when a defect appears, a judge cannot simply fold his hands and blame the draftman. He must set to work on the constructive task of finding the intention of Parliament." He went further and said, "Put into a more homely metaphor, it is this: a judge should ask himself the question, if the makers of the act themselves come across these knots in the texture of it, how would they have straightened it out? He must then do as they would have done. A judge must not alter the material of which it is woven, but he can and should iron out the creases." That is the position of Lord Denny. That if the court should not close his eyes and say, yes, because that was what the draftman, the legislature has done, then so be it. The Lord Denny is saying that the court ought to put himself in the position where if the legislator, the draftman, were to be present, that will he apply the error that he has made like that without doing justice? And that's why in that submission, Lord Denny went further to say that there is need for the judge to look at the best way to derive the purpose for which the same law is made, even though he cautioned that the judge must not alter the material with which the law is woven, but he should iron it out to be smooth enough to serve the purpose for which it has been enacted. That's the position of Lord Denny, which I believe is clear enough, is simple enough to understand. I will refer you to another case of Magor versus Newport Corporation. Magor versus Newport Corporation. In this case also, Lord Denny said something further, which I'm also going to quote for you. He said, "We sit here to find out the intention of Parliament and of ministers and carry it out. And we do this better by filling in the gaps and making sense of the enactment than by opening it up to destructive analysis." Though another judge promptly denounced this position that Lord Denny held. What Lord Simons at the House of Law said was that it is sufficient to say that the general proposition that it is the duty of the court to find out the intention of Parliament cannot by any means be supported. So the duty of the court is to interpret the words that the legislature has used. Those words may be ambiguous, but even if they are, the power and the duty of the court to travel outside them on a voyage of discovery are strictly limited. Thank God that Lord Simon said that the judiciary or the court can travel, but a caution that this journey must be limited. And of course, that is not completely against the position of Lord Denny MR. Lord Denny did not say that the judge should travel far, wild. No. Just like Lord Simon said, there must be limitation to the journey that the judge or the court will take in order to discover the intention of Parliament. So therefore, giving life to the law as contained in the rule is of utmost importance, and that is where the golden rule of interpretation is very handy. When they discover the gaps, yes, even though the best remedy will be for the legislature to go and amend the law, but what will happen to the instant case that is being considered? And that's the position of Lord Simon. He said, if a gap is discovered, the remedy lies in an amending act. That is, the law should be amended. Lord Morton is spelled O-M-O-R-T-O-N. Lord Morton expressed a similar view. He said, and I quote, that it is not a function of any judge to fill in what he conceives to be the gaps in the Act of Parliament. If he does, he usurps the function of the legislature. Now, coming home, the Supreme Court of the Federal Republic of Nigeria has applied this golden rule of interpretation in some cases. Though the Supreme Court did not expressly mention that, oh, we are applying the golden rule of interpretation. That is, in the wisdom of the court applied the golden rule. Now, I refer you to the case of Adamolekun versus Council of the University of Ibadan. Okay? In Adamolekun versus Council of University of Ibadan, Section 6 of Decree number 1 of 1966 provides that in that case, of Ademolekun versus the Council of the University of Ibadan. We are talking about Section 6 of Decree number 1 of 1966. This is what the decree provides. It says, no question as to the validity of this or any other decree or of any edict shall be entertained by any court in Nigeria. What the Supreme Court held was that of course, that is more like what we call hostile clauses. It's the law, that decree is ousting the jurisdiction of the court. It's taking away the power of the court to look into the provision of that law. But what the Supreme Court said is that the hostile clause does not preclude the court from inquiring into any inconsistency that may arise between an edict and a decree, but merely bars the court from questioning the validity of making a decree or an edict on the ground that there is no valid legislative authority to make one. That was the position of the Supreme Court when it was referring to when it was dealing with the case of Ademolekun versus Council of the University of Ibadan as it relates to Section 6 of Decree number 1 of 1966, which simply says that no question as to the validity of any or other decree or any edict shall be entertained by any court of law in Nigeria. And what the Supreme Court, in its wisdom, did was to state, even when the opponent was maintaining that, oh, this is the position of the law, the Supreme Court cannot venture into this case because of the provision of Section 6 of Decree number 1 of 1966. But the Supreme Court said this ouster clause does not preclude the court from inquiring into any inconsistency that may arise between an edict and a decree. So meaning that if there is an inconsistency between an edict, for the purpose of others who may not know, an edict is a law made by a military government in a state during military regime, while a decree comes from the federal. So the Supreme Court said, if there is an inconsistency between the two, the court can inquire into it in order to set up, to make it straight. But that if in relation to the Section 6, Decree number 1 of 1966, that which bars the court, yeah, that is understandable. But in the area of inconsistency, the court has a duty to make a way to clarify issue. Another example that will be given on this topic is the case of Ohuka, OHUK, versus the states. Ohuka and the states. Here we refer to Section 31 of the Supreme Court Act of 1960. What does it say?
81.
Section 32, sub 2.
Three.
The period for the giving of notice of appeal or notice of application for leave to appeal are, in an appeal in a criminal case, 30 days from the date of the decision appealed against. Sub 4 of that law says that the Supreme Court may extend the period prescribed in the Section 2 above, except in the case of conviction involving sentence of death. So, how does this relate to this case? Let me repeat what I've said on this case for proper understanding. We are talking about the case of Owuka and the state. And the law in view on this case as it relates to the topic we are dealing with is Section 31 of the Supreme Court Act of 1960, which simply provides that the period for giving of notice of appeal or notice of application for leave to appeal are, for example, in an appeal in a criminal case, 30 days from the date the decision appeal, the decision of the decision appeal against. Also, that same provision of the law, the law went further to say that the Supreme Court may extend the period prescribed in Section 2, that is the 30 days, except in the cases of conviction involving sentence of death. Meaning that the only place that the Supreme Court cannot extend this period of 30 days is in a case involving someone that has been sentenced to death. So in this case of Owuka, the appellant was in custody and he was not aware that judgment was given. When he became aware, he appealed against the judgment. His Lordship, Oputa JSC, who wrote the leading judgment in the case, construed the 30 days to mean 30 days after the appellant had knowledge of that decision. And His Lordship pertinently observed. So what it means is that the purpose of the law is not to rob that individual of his right to appeal, but is to ensure that proper things are done within the right time. So my Lord thought that since the individual was in prison, he didn't have knowledge of that judgment. Therefore, that particular 30 days will not start counting unless at the date which the individual had notice of it. What his law said is this. His Lordship said is this, and I quote. He said, the court is not a mechanical and automatic calculator. No, it is a court of law dealing with varying situations and applying the same law to these situations in order to do justice in each and every situation according to its peculiar surrounding circumstances. Now, what is the court saying by this quotation? The word of the legislation, that law, is that in that case, or on the surface of it, literally suggests that once the 30 days has passed, the right to appeal is foreclosed. Whether the appellant or whether the party in question had notice or not. Especially in the case of this Owuka, the man was in prison. Apparently, he was not represented by a lawyer, and the judgment was delivered, and he was not aware. But when he became aware, he brought an application. And of course, the Supreme Court felt that if we are to apply the literal rule, this man will just suffer for nothing because he was not the one who locked himself within the prison wall. Probably if he was a free man, he would have been in court when the judgment was delivered. But the Supreme Court looked at it from a different way and said, no, the man was not aware because of his location. And that's justice to me, but to others, it may not. But of course, we are entitled to our opinion. So the court preserved the right of Owuka to appeal. In another case of FCSC versus Laoye, Federal Civil Service Commission versus Laoye, the Supreme Court observed that although generally it is for the legislature to change the law when it desires to do so, he said the court can and ought to correct obvious slips in drafting. In such cases, it is permissible for the court to depart from strict application of the literal rule of construction in order to give good effect to the legislature's intention. That's why the court is not expected to be a rubber stamp. And that's one of the major points we made as one of the criticisms of the literal rule of interpretation. So therefore, and as noted earlier, prima facie, words used in a statute must be given their ordinary meaning. However, where the literal interpretation tends to derogate from the intention of the lawmaker, or where it will lead to absurdity or injustice, or even to what we can mildly refer to as unreasonable result, the language may be varied to avoid such absurdity or injustice and nothing more. So with that, I'll say that we have done justice to the golden rule of interpretation. I'll leave the floor open for any question before we call it a day. Just have like 5 minutes to the end of the class. Yes, Collins.
Okay, sir. So I have a question. I wanted to, because while I was listening to when you were explaining the golden rule of interpretation, I don't know, you said that the rule was formulated by Lord Denny, but according to my own research, it was, what I saw there was that it was actually formulated by Baron Park in the case of Beck versus Smith in the year 1836. I don't know if that is true, sir.
You heard me clearly. If you listen to this recording again, I said that this particular rule is attributed to the celebrated case of Park B, when he decided Smith, Beck, and Smith. And what I said about Lord Denny is that Lord Denny is one of the most outstanding exponents. Park B must have made an avenue to create something that looks like the rule, but it needed people to carry it, to use it, to preach about it, for the rule to become known. And that was why I can remember the language I used, that Lord Denny is one of the most outstanding and more exponents of the golden rule of interpretation. So I didn't say that it was
Okay.
Lord Denny who originated it. Yes.
Thank you, sir. What is the name of the case, sir? Can you repeat the name of the case again, sir? Thank you, sir.
Beck and Smith.
Not that one, the one Lord Denny exposited his own take on the golden rule.
Seaford Court Estate. The Seaford is one word. C as in SEAFORD. Seaford Court Estate Limited versus Asher. Asher is spelled ASHER. And also he went further to say more on it. In the case of Magor, Magor is spelled MAGOR versus Newport Corporation. Okay?
Thank you, sir.
You're welcome. All right, so with that question and the absence of other question, we call it a day here. And by God's grace, when we meet next, we shall look at the other rule of interpretation. Thank you very much for listening and enjoy the rest of the day. Bye.
Bye.
Thank you very much, sir.
Thank you, sir.
Bye-bye, sir.
Thank you, sir. Bye.
Thank you, sir.
Bye, sir.
Thank you, sir.